Hi folks, and welcome back to Meaningful Money. Okay, I'm here at Lamorna Cove again. Been here before, but the aspect was slightly different. Yeah, that's the cove behind me. Quite a rough sea today, so I hope you can hear me above the noise of the waves crashing on this wall I'm sitting on. We talked last time about the powers and duties of trustees, the statutory ones, the ones laid down by the Trustee Act 2000. But there are more to consider, and these are what you could call common law duties and responsibilities, because rather than being laid down by an Act of Parliament, they are laid down in precedent. So previous court cases where there has either been a judgment or comment by the judge about how the trustees in those cases have acted, and those judgments or comments impact what trustees can do from that point on. So this is powers and duties set in place by legal precedent. And there are 6 broadly to speak of, 6 common law powers and duties. So let's go through them one at a time. The first one is to ensure that any investments made by the trust are suitable. Now that might seem really obvious, and of course it is. But the problem with that is that it's a little bit anecdotal, and what is suitable or otherwise depends on various things, and it can depend on prevailing economic conditions at the time, what markets are doing. So in a falling market, it might be deemed that a cash investment or a gilt investment would be suitable, but in a rising market, it would be deemed unsuitable to hold money in cash when trustees could be taking advantage of a rising market. So the problem is it's a little bit subjective, that. Obviously, suitability includes diversification, spreading the money around. But importantly, when it comes to ensuring investments are suitable, the trustees cannot apply their own particular sort of beliefs or convictions to trust investments. Now, let me give you an example. Let's say a trustee had deep ethical convictions and didn't want personally to invest in anything to do with arms or tobacco or whatever. Well, that trustee would not be allowed to impose his or her views of investment on the trust investments. He can do what he wants with his own money, but not with the trust investments. The overriding sort of criteria, if you like, is the suitability of the investments for the trust, not what the trustees feel strongly about. So that's the first common law duty, to ensure that investments are suitable. Sounds common sense, and indeed it is. Secondly, there's a duty to take account of settlor's wishes. A settlor, remember, is the person who sets the trust up. And this again might seem really obvious, but once the settlor has handed money into trust, he or she may well be one of the trustees, so will have an impact on how that money is invested or distributed or whatever. But the money is not his anymore. It's not the settlor's anymore. He's given it away. But there is still a duty to take account of the settlor's wishes. There's a duty on the trustees to do that. So in the case, say, of a discretionary trust, where the trustees have power to exercise discretion as to who should benefit from the trust, they still have a responsibility, a duty even, to take account of the settlor's wishes. So the settlor could write a side letter and say, in your capacity of trustees, I would like you to give due consideration to my son Jim. Now that's not binding on the trustees, but they have a duty to take it into account, so it's a fine line. Number 3 is to ensure fairness between different classes of beneficiaries. So take your average interest in possession trust. You remember from a couple of videos ago, there is a life tenant who will have a right to, say, the income from the trust while he or she is alive. But eventually the capital will be given to what's called the remainder men, the residuary beneficiaries. So you've got 2 different classes. One class of beneficiary gets an income, the others get the capital eventually. Well, trustees have a duty under common law to take account of both classes of beneficiary. They can't favour one over the other. Instead, they have to bear both in mind equally. It's an important one I come across very frequently in my job, advising trustees as to their trust investments. Fourthly, there's a duty to monitor investments. That means obviously to keep them under review and to take advice if they are not suitably qualified to review those investments themselves. Just keep the investments under review. That might seem obvious, but this is a common law duty. It's important. Number 5 is not to hoard cash. Another important one. it might be tempting for trustees who are legally liable for what they do as trustees and how they invest their money. It might be tempting for trustees to sort of bury their heads in the sand a little bit and shove the trust money under a mattress or its real life equivalent, which is just bung it in the bank and get some interest on it. But actually that's illegal, and there have even been court cases where trustees have been successfully sued for holding on to cash just for 3 months. So there is a very clear duty not to hoard cash. Now, excluded from that is money which is going to be needed in the very short term, or property which a beneficiary is living in, but it's quite a clear instruction: trustees cannot hoard and sit on large amounts of cash. Finally, there is a duty on trustees to take account of tax considerations. Again, it's common sense to you and I, but it's laid down in common law through legal precedent to take account of the tax consequences of everything they do, not only for the trust itself, but also for the beneficiaries. So we've covered now the statutory powers and duties back last time. This now is the common law powers and duties, and hopefully what you're getting from this is that being a trustee is not an easy ride. There are many considerations. But it's also an immense privilege if somebody has asked you to look after their affairs on their behalf, either after they've died or perhaps when they're not capable anymore of looking after them themselves, or just to be a trustee even if they're still living and still capable. It's a big deal though, and certainly not something to be taken on lightly, because you are subject as trustee to all these powers and duties laid down by the law. So any questions on any of those, then feel free to leave comments either on the website or Facebook, wherever, and I'll do my very best to answer them. So next time we're going to go on to taxation, how trusts are taxed. I'll try and keep it as light as I can. But for now, from Lamona Cove, thanks very much for watching, and I'll see you next time.